Good afternoon, everyone. 皆さん、こんにちは。I'm Jialin from the Department of Sociology, National Taiwan University. It's my great honor to introduce today's speaker, Professor Sara Friedman. Professor Sara is a distinguished scholar at the Institute for Gender Studies at Ojanori University. She has long been engaged with research on bioethics and gender studies. Her expertise includes ethical and gender-related issues in reproductive medicine, with particular attention to third-party reproduction, gamete donation, and the right to know one's origins. She has accumulated more than 15 years of research experiences in the field and has led several international comparative research projects on donor anonymity and the rights of donor-conceived children. In addition, she has examined the diverse family forms created through assisted reproductive technologies and their broader social implications. What I find especially inspiring is that in addition to her excellent scholarship, she founded an NGO, Donor Link Japan, to raise awareness in Japanese society about the rights of donor-conceived individuals to access their genetic information, including the right to know their origins. Last summer, did you have a book with you? Oh, here's the book. Donor Link Japan published a book. Published a book. 私は何者かを知りたい。I would like to know who I am, which brings together the experiences of donor-conceived individuals as well as the parents, doctors, and policymakers. Professor Sara will speak about this book tomorrow afternoon at the Feminist Bookstore in a section moderated by Professor Huang Yulin. Today, Professor Sara will focus on the recent developments in lawmaking in Japan. Her talk is titled Critical Concerns Regarding Japan's 2025 Donor Confection Bill. Although there has been cross-border reproductive care between Taiwan and Japan, we know relatively little about the legal debates in Japan. And our legislature is currently revising the Assisted Reproduction Act. As it is happening, the developments in Japan offer valuable reflections and comparative perspectives on our own regulatory framework and practice. We are also fortunate to have Professor Sara Friedman as our discussant. Professor Friedman is a professor in the Department of Anthropology and the Gender Studies program at Indiana University in the United States. Her current research focuses on the family making among LGBTQ people in Taiwan. She's teaching queer families in global perspective in our department this semester and will give a talk here. Oh, not here, in the sociology building next Thursday. Please follow the NTU Sociology Facebook page for more information. So today's event is co-organized by several groups. The Taiwanese Feminist Scholars Association, our president, Wang Shuying, is coming, and the many members are here with us today. Another organizer is the research group Reproductive Technologies and Society at the Department of Sociology, National Taiwan University. And we are very lucky to have some fundings from the National Science and Technology Council and Taipei City government. We thank all the organizers and especially our staff, Yiqi, Conan, and Yang Juan, and you. So the presentation will last about 1 hour. followed by Professor Friedman's 15 minutes comment, and then we'll open the discussion to the floor. Without further ado, please join me in welcoming Professor Friedman.
你好，我是仙波由加里。This is the Chinese I don't customize. I just know only two Chinese words, 你好, how to say it. Anyway, today I will speak in English, and my English is not good, but please forgive me. Good afternoon, everyone. My name is Yukari Senba. I'm affiliated with Donald Japan, a non-profit organization, and Ochanomizu University. First of all, I would like to thank Professor Chairman Wu for inviting me to speak here at National Taiwan University and for giving me the opportunity to share the issues surrounding donor conception. Donor conception in Japan with an audience in Taiwan. I would also like to express my gratitude to Yuchi and Chuan and Conan and other staff. Thank you very much for arranging my stay in Taipei. I'm truly honored to be here today. I'm currently a researcher at the Institute for Gender Studies at Ochanomizu University. In addition, in December 2022, I co-founded Donali Japan with several colleagues, and I'm actively involved in supporting donor-conceived people as well as gamete donors. Today's talk will focus less on my academic research and more on the current situation and emerging trend in donor conception in Japan. This is because, as in Taiwan, gamete donation is generally practiced under the principle of donor anonymity in Japan. I would like to highlight the issue that arise from the anonymity, well as the challenge faced by donor conceived individuals who don't know the identity of their donors. In February last year, a bill related to donor conception was proposed in Japan, which sparked a wide range of opinions. Today, I will also explain the key features of this bill and share my thoughts on why it takes its current from despite significant criticism. First, I would like to begin by providing an overview of the current state of ART in Japan. Japan is one of the countries with the highest number of ART procedures in the world. In 2018, the number of ART treatment cycles performed in Japan, including IVF and ICSI, was the second highest in the world after China, surpassing even that of the United States. Furthermore, the number of children born through ART in 2023 reached a record high of about 85,000. This accounts for about 11.3% of Japan's annual birth of about 750,000, meaning that roughly 1 in every 8.6 children born in Japan in 2023 was conceived through ART. So very ART country, but as of 2026, Japan still lacks comprehensive legislation governing ART and continues to rely primarily on guidelines issued by the Japan Society of Obstetrics and Gynecology. In Japan, for ART using donor gamete is also on the rise. One reason is that it is estimated that 1 in every 100 men has azoospermia, meaning that there is a steady demand for donor sperm. Furthermore, as is likely the case in Taiwan, more women in Japan are entering the workforce, and an increasing number are choosing to delay marriage and childbirth until they have established their career to some extent. In 2023, the average age at first birth in Japan was 31.5 years, and 31% of women who gave birth that year were age 35 or older. As women age, there is a growing tendency to seek egg donation. However, until very recently, egg donation was effectively prohibited under the guidelines of the Japan Society of Obstetrics and Gynecology, making it difficult to determine how many women are actually using this option. In addition, in recent years, it has become increasingly common for lesbian couples and single women to seek sperm donation in order to have children. Given this trend, the demand for donor-assisted reproduction in Japan is expected to increase further. However, no laws governing ART and donor conception have yet been established in Japan. The need for legislation on donor-assisted reproduction has been recognized for more than 25 years, and its details have been examined by government bodies and the Science Council of Japan. This diagram illustrates the history of legal development in ART in Japan. In 1979, the Japan Society of Obstetrics and Gynecology, we call it the JSOG, published the guidelines on sperm donation. Subsequently, the need for legislation, including provision to safeguard the donation, safeguard right of donor-conceived people, was recognized, and deliberations continued for about 20 years. In February 2020, the Special Measures Act on the Civil Code was enacted as Japan's first law addressing donor conception. However, as I explain in detail later, this act defines parent child relationships formed through ART donor conception under the Civil Code and does not include any provision governing the procedure themselves. Legislation governing donor-assisted reproduction has been slow to materialize. On February 5th, 2025, last year, the Specified Assisted Reproductive Medicine Bill, hereafter I call it the donor conception bill, was submitted to the House of Councillors by 4 political parties: the Liberal Democratic Party, Komeito, the Japan Innovation Party, and the Democratic Party for the Future. People. The bill has faced strong criticism from donor-conceived people, recipients, parents, and others involved in donor conception. Why has the February 25th draft or the donor conception bill won so much criticism? understand that this question, it is important to look at the 2020 Special Measures Act on the Civil Code. The legal framework established by this act can be summarized as follows. First, the woman who gives birth is recognized as the legal mother. Second, the husband is recognized as a legal father, provided that he has consented to the use of donor sperm, and this legal status has been consented. However, the Act does not include any provision regarding the legal status of gamete donors. In the Act, Article 7 of the supplement provision states as follows. In order to ensure the appropriate implementation and provision of ART, the following and other necessary matters will be reviewed in approximately 2 years, and legislative and other necessary measures shall be taken based on the result of this review. So, it was expected that legislation to protect donor conceived people's right to access information about their donor would be submitted in 2022. Because our organization, Donor in Japan, we have many donor conceived people members, so we are expect to have that role of person. So from 2022 to 2023, bipartisan parliamentary caucus has worked on drafting a bill. On November 7, 2023, at the second draft outline of a bill on ART using donated gamete was presented at the 25th General Meeting of the Bipartisan Parliamentary Caucuses for considering the future of ART, which we will refer to as GM. We always call it as GM. Now, I would like to explain the main provision of the draft bill 2023. First, the bill established a legal framework for donor-assisted reproduction in Japan. At the same time, it limits access to reproductive technology to legally married heterosexual couples. In addition, the bill requires government authorization for both medical institutions and intermediary agencies involved in donor-assisted reproduction. It also prohibits the commercial trading of gametes and introduces penalty for violations. Furthermore, the bill creates a centralized data management system under which records will be stored for up to 100 years. Finally, it introduces what can be described as a partial right to know. Under this system, donor-conceived individuals can access non-identifying information about the donor, while access identifying information is permitted only with the donor's consent. In response to the draft bill, donor-conceived individuals, recipients, and intended parents submitted comment to the bill drafters, calling for amendment. In addition, the Japan Society of OBGYN, JSOG, as well as other experts, expressed concern about the provision related to the right to know. It was also pointed out that donor-conceived individuals recipients, and donors who are not included in the working group responsible for drafting the bill, which raised further concern about the process. As a result of this widespread criticism, the draft was ultimately not submitted during the extraordinary session in 2023. In February 2025, lawmakers from both the ruling and opposition parties in Japan submitted a new bill on donor conception. This was the bill was jointly proposed by members of the ruling Liberal Democratic Party and Komeito, as well as opposition parties, including Nippon Kishin no Kai and the Democratic Party for the People. This bill is known as a specific assisted reproductive medicine bill. We call it the Tokke Seishoku Hojo医療法案 in Japanese. Here I refer to it as the Donor Conception Bill 2012. The aim of this act are, first, to ensure the proper implementation of donor-assisted reproductive technology, and second, to enable donor-conceived people to access information about their donors. Next, I will outline the main provision of the Donor Conception Bill 2025. First, donor-conceived individuals are allowed to request information about the donor from the age of 18. However, only non-identifying information such as donor's height, blood type, and age at the time of coming to donation is available as a general rule. Access to identifying information is permitted only if the donor has given consent. In addition, the bill provided for the creation of government administrated information management system. And no donor information is disclosed to the recipient. In addition, the bill restricts access to reproductive technologies to legally married couples. As a result, same-sex couples and married cohabiting opposite-sex couples and single individuals are not permitted to use these technologies. This bill also introduces penalty for violations of these provisions, including imprisonment for up to 2 years, or a fine up to the 3 million yen. It's about 600,000 Taiwan dollars. And furthermore, the law explicitly states that recipient couples have a duty to make responsible effort to provide information to the child about the circumstances of their birth. Information on donor, recipient couples, and donor-conceived people will be retained for 100 years by government administrative information agency. In addition, medical institutions and that handle donated sperm and egg are subject to a certification system. At the same time, agencies that act intermediary between donor and medical institutions are required to obtain licenses. The bill also extends its scope beyond Japan. In some cases, receiving such a medical treatment overseas may be subject to penalty under the extraterritorial application of criminal law. So the question limit access to legally married heterosexual couples. Why? I met with Kuozo Akino in April last year. He is a lawmaker from the ruling coalition involved in drafting the bill. When I asked him why does the Donor Conception Act restrict the use of DRT involving donated gametes to heterosexual legally married couples, and he replied the following. He stated that ART should not be pursued at the expense of the well-being of donor-conceived people. He also emphasized that it is preferable for children to have a legal father. Therefore, assisted reproductive medicine using donor sperm is permitted only for legally married heterosexual couples. It means that for donor-conceived children born to married couples, legal paternity is clearly established, enabling the formation of a stable parent-child relationship that is beneficial to the child's well-being. It also argued that if the couple is not legally married, the child would have no legal father. Therefore, if the donor is identified, the child's mother may ask legal recognition of paternity, child support, or the child may seek inheritance rights. So to protect the donor, access should be limited to married couples. In an interview by journalist Iwanaga, published in April last year, Akino made similar remarks to her. So anonymity is justified on the ground that it protects the donor from obligations such as legal recognition of paternity and child-rearing responsibility, as well as from inheritance claimed by donor-conceived child. Even the lack of the defined legal status for sperm donors. This is cited as a basis for supporting donor anonymity. Take a moment to look back at the Act on Special Provision of the Civil Code 2020. This Act defines the parent-child relationship in case of ART involving donor gametes. However, it does not address the legal status of sperm donors. The lawmakers assumed from the outset that access to donor conception will be limited to legally married couples. Therefore, so no need to specify the legal status of donors. So, if this bill is enacted as a current draft, the following may occur. There are already many parents in Japan, including those with de facto couples, single women, and same-sex couples who have had children using overseas government funds and medical institutions. Children raised by such parents may come to view their own birth negatively. And society may also view them with prejudice the children born through illegal procedure. Next, I would like to discuss the right to know one's origin. That is the right of donor-conceived persons to obtain donor information in the context of donor conception. The bill provides the following. Under the donor conception bill, donor-conceived persons are prohibited from obtaining any donor information under they reach the age of 18. Even after reach the age of 18, individuals who request disclosure of donor information are generally provided only with limited details such as the donor's type, height, and age at the time of the donation. If they seek additional information, they must contact the donor through government administrative information management agency, and only the information to which the donor has consented will be disclosed. The bill also proposes a fine of up to 300,000 yen, saying $600,000 by Article 77 for parents and children who obtain a donor's personal information without following the proper disclosure procedure. So, donor in Japan may also be subjected to such a penalty if this law would have been enacted. Why is the right of donor-conceived people to know treat with such a discarded? The drafters of the bill argue that donor recruitment would be difficult without anonymity. However, this claim is not necessarily accurate. Even in Japan, there are some banks and clinics that recruit only donors who are willing to reveal their identity, yet they are still able to attract donors. The bill also states that ART using donated gametes permitted only at government certificate medical institutions and prohibits the use of overseas gamete banks and medical institutions for the pursuit of pregnancy and childbirth. I had experience of GP treatment in the US, and at my age, at that time, the doctor recommended me to use the donation. But if in a case, probably I would have to go to jail. Yeah. Okay. Yeah, this bill, yes. And the further state that individuals who use overseas sperm and egg bank for medical institution may be subject to criminal penalties. There are many children in Japan born to parents who have used overseas sperm banks for medical institutions. If such actions were to be criminalized, this could have a significant psychological impact on these children. In addition, if this bill is enacted as currently drafted, recipient parents may not be able to access information about the donor. However, medical and genetic information about the donor and the donor's family is essential for parents raising a child in order to protect the child's health. On April 9, 2025, donor-conceived people, recipient parents, lesbian mothers, single mothers, and intended adherents using donated gamete held an emergency online event to call for amendment to the Donor Conception Bill 2025. A total of 580 people participated in the event. So if people see the video. So I would like to summarize my presentation. Many laws in other countries regarding donor conception stipulate that the donor is not the legal parent of the child. To my knowledge, no law allows donor to determine the scope of disclosure of their information. I was unable to find any country that prohibited the use of overseas gamete bank or medical institution and imposes penalties for such violations. The 2025 bill cannot be said that the right of donor conceived individuals to know their origin is adequately respected. Once this law takes effect, it will become more difficult for people who are not legally married to form families. Such as the 2025 bill faced significant criticism for individuals involved in donor conception and other stakeholders. Consequently, the bill was not debated during the regular diet session held from February to June 2025 and was withdrawn when the different. Sorry. Sorry. Here is the as such. The 2025 bill faced significant criticism from individuals involved in donor conception and other stakeholders. Consequently, the bill was not debated during the regular diet session held from February to June 2025 and was withdrawn when the diet ended. However, there is a speculation that the bill to replace the 2025 bill may be submitted again this year. But at least there have been no reports of donor conceived persons or recipient parents participating in the deliberation for drafting the bill. We must closely monitor the extent to which the opinions of those directly affected are reflected in the bill. If this bill is enacted as the 2025 bill, there are concerns that there will be an increase in high-risk trade in gamete on the black market. The Japan Society of Obstetrics and Gynecology is currently lobbying for its makers to enact legislation stipulating that gamete donors are not and cannot become the parents of donor-conceived children in order to protect donors. However, it remains unclear to what extent the current Takaichi administration, which opposes both same-sex marriage and the option of separate surname for married couples and held very conservative views, will address issues related to donor conception in Japan. Thank you very much for
Thank you much, Ikari, for your very informative presentation. I think many users and medical institutes in Taiwan should have paid more attention to the bill, because they might be punished after the bill was passed. There has been much cross-border here between Japan and Taiwan. So before we open the discussion to the board, let's welcome Sara for her comments.
Thank you, Professor Semba, for a very interesting presentation. I think there's a lot to say and a lot to discuss, and I will keep my comments brief for that reason, so we have time for question and answer. I think Professor Semba's presentation shows us very clearly some of the lessons that we have learned from feminist STS studies and feminist legal studies, that neither technology nor law are neutral forces, and we need to interrogate the kinds of power hierarchies and inequalities that are encoded in and enacted through both science and technology, and how they are regulated in different national settings. I think we see very clearly from this presentation the role of stigma as a powerful force, both in law and biotechnology, as it is enacted through the use of technologies, through how technologies are understood and defined, and also as they are regulated and laws are put into place and enacted. And with that in mind, I think we also see the need to think about the temporality of legal regulation, whether it is retrospective or whether it is also future oriented. So how an act of family making that maybe it was not accepted, at least was not criminalized, could become transformed into a stigmatized, criminalized act. I think we can talk about maybe the comparative case of Italy right now too, which has also rolled back some of its recognition for non-mainstream heteronormative families. So from Professor Semba's talk, we see the value of this kind of an approach to understand Japanese debates about the legal regulations of ART and donor gamete use. So I just want to briefly summarize what I see as some of the assumptions, normative assumptions that are included or baked into the draft law, as Professor Semba very clearly shared them with us. One is that only opposite sex married couples are seen as appropriate parents in Japan, and that a child needs a legal father. So paternity is a very powerful legitimating force, and the message in the way the law is drafted is that intending parents can use ART as long as they create a heteronormative as a consequence. And I think here, Professor Semba alluded to some of the ways that these potential ART laws interact with laws and regulations related to Japan's household registration system, the koseki, and the requirements around heterosexual marriage. For instance, that a married woman take her husband's name to be able to then enter his koseki, and the strategies that feminist-minded women have adopted to work around those restrictions. So thinking about how those stigmatizing effects cross-cut different legal and regulatory domains, I think is very useful in this case. A third assumption is that gamete donors desire anonymity, and that heterosexual parents desire to cover the use of donor gametes. those are assumptions, that there is a stigma attached to using donor gametes, and that there is primacy or normativity attached to having a biogenetic connection between a parent and a child as the most desirable and authentic kind of connection. All of which I would say are assuming heterosexual intending parents are using gamete donation and ARTs. And then finally, that the best interests of a child conceived through donor gamete use, those interests are not weighty enough to cancel out the expectation and desire for donor privacy. So in essence, the donor's assumed desire for privacy trumps the best interests of the child to know their origins, and assumes that perhaps, I might be reading into the law here a little, that a child who knew they were conceived from gamete donation would feel stigmatized by that, right? And I think here there are lots of lessons to be learned, and Professor Wu shared the article from the reporter in Taiwan that queer parents have been doing a lot of work to develop strategies and lessons for how to share that information in a healthy manner with children so that they are confident in who they are and their family organization. But so that assumption of stigma is encoded in the law. So what are the consequences then if this law were to pass in its well, not current form, the form that it took in 2025? Obviously, single women, same-sex couples, and unmarried heterosexual couples would no longer have access to ART in Taiwan, in Japan. And that those who have children already conceived through ARTs and donor gametes would be stigmatized as a consequence. And it's interesting, and maybe this is the English translation, that draft law used the language of married couples. And I was curious whether it had any language around married same-sex couples. I know it's not legal in Japan, but a Japanese same-sex couple could go to a third country to marry. Would they then count as a married couple for purposes of this law? Or a non-Japanese couple married, say, in Taiwan, going to Japan? I don't know if the law clarifies in that way. That's interesting to know. Or in addition to limiting ART access to married heterosexual couples, does the draft law also limit it to Japanese nationals or not? Interesting question. And I ask these questions because, as Professor Wu suggested, Japan is very much of a destination for cross-border reproductive care for Taiwanese lesbian couples, especially after Thailand revised its ART access law in 2015. And in 2017, lesbian mother in Taiwan shared her experiences going to Japan, her and her partner's experiences going to Japan to conceive through IVF and sperm donor use from an international sperm bank. So it is now a very desirable destination where Taiwanese co-mothers use gaps in the law to seek treatment as single women. Should Japan become inaccessible as a consequence of this law, then there would be, I think, significant questions about other destinations that could come to the fore. Right? An example of what medical anthropologists have called shifting repro webs that are defined by different combinations or assemblages of technologies, of expertise, of law, of labor, and of cultural and moral values. So after Thailand, we see a shift towards Cambodia and then Japan. Obviously, the US and Canada as possibilities, but much more expensive and time-consuming. So there would be significant consequences in Taiwan were this kind of a law with these restrictions. So just very briefly, a few comparisons with the draft ART law that was proposed by Taiwan's Executive Yuan in December of 2025. That draft law similarly places a high emphasis on donor anonymity and privacy in a way that outweighs a child's right and need to know and understand their origins. And the kinds of basic information that is provided when a child reaches age 18 is quite similar to the Japanese law. Height, blood type, race, nationality, among those. On the criminalization question, this I think is really worth talking about more. The Taiwan draft law criminalizes importing gametes from international commercial gametes. But it is by no means, it does not impose the same kinds of penalties that the draft law in Japan is proposing that criminalizes engaging in banned procedures overseas, right? And that is a significant difference. That raises a whole set of questions around enforcement and tracking. There are, I think, interesting comparative cases. Germany, for instance, where surrogacy is not legal. There are concerns among German intending parents who go abroad for surrogacy that they would be penalized upon return. They also face obstacles regularizing the parental and citizenship status of their children because of that potential for criminalization. And then Italy, as I mentioned, a country that recently has also tried to criminalize going abroad for banned procedures, and also reversing legal recognition of same-sex co-parentage that was previously granted by city, local level governments. So that's another comparative case. Differences from the Taiwan law, or the draft that the Executive Yuan has put out, is that the Taiwan law does specify that a donor is not a parent. And it does that because it cannot assume a heterosexual couple in the way that Japan's law does. So it spells out explicitly that the donor has no parental status and that a child conceived through ART is seen as a, quote, marital child. The interesting language, it applies even if the intending parent is a single unmarried woman. Her child is still a marital child precisely to avoid a donor being potentially seen as a parent. So I can say more, and I'm happy to offer some insights with from some initial interviews I've been doing with intending queer mothers in Taiwan, their thoughts on the Taiwanese draft law and how it would affect their reproductive decision-making should it pass in its current form. But I think the larger message to take away from the valuable insights that Professor Shamba has given us is that ART, both as it's enacted and as it is regulated, interacts in very complicated ways with politics and different political orientations and positions. And there are always the possibility for strange bedfellow coalitions to arise. And these are ones I think we need to be wary of, as feminists have argued in other contexts in regard to other topics, that we have to be really carefully attuned to what the consequences of different legal framings, different regulatory framings, and what technologies enable, and also what they then further stigmatize by excluding from the domain of family. So I will stop there and thank you very much. Thank you very much for your comments, Sarah. It's very beautiful, precious for me, and so I'd like to learn more about the situation in other countries. You introduced Italy or Germany. Yeah, we should research about and yet the bigger discussion. I'm really looking for.
So let's open the discussion to the floor, and I think every participant, including the participants online, can raise your questions. And please briefly introduce yourself and can have comments, or you have some questions for or Friedman, or other participants, because we have many experts here, or social studies of reproduction, so anyone can jump in and share your ideas. So anyone want to be the first? Oh, what may, yeah,
First of all, thank you, Professor Senpai. It was really very informative and interesting for me to learn about Japan's development and very important indeed. So thank you a lot for sharing them with us. I have 3 questions, so forgive my ignorance of Japan's situation. Is first of all, right now we are also revising our Assisted Reproductive Act, and it seems like all parties now have draft to permit LGBT groups and single women to use ART, even though it's not passed yet because of there are other things more pressing in the legislature. But seems like all the major parties agrees that this should be open. But actually, this is a very difficult result, because judging from we had a referendum in the 2018. The referendum we lost. I mean, the LGBT group lost in terms of legalizing the marriage for LGBTQ. It wasn't permitted until the Constitutional Court in 2017. They ruled that the civil code is against the freedom of marriage, and but even after that, the referendum lost. Therefore, the government very strategically passed a law in 2019, which is the deadline provided by the Constitutional Court, that you have to permit LGBTQ to have same-sex marriage. That was in 2019. Okay, but 5 years later, now every political party in the legislature supports ART for LGBTQ. So my first question would be, because to me, I think it's easier for people to accept marriage for LGBTQ before accepting ART for LGBTQ people. So I wonder if there has been such kind of voices or effort in Japan to legalize same-sex marriage before the advocacy for using ART for same-sex people. That's my first question. And my second question is about, I'm also always been very curious about why is professional society so dominant in ART? And until now, there was talk about law. And I wonder if this situation is unique to ART, or is it also in other medical law? For instance, in the area of do not resuscitate, or the area of organ donation, are there also just guidelines or are there laws that regulate about these things? Because I can imagine the medical society is quite powerful in Japanese society, but is this unique only in ART or is it in every area of health? And the final question is about punishing parents going abroad to have gamete donation. And I wonder, was there any rationale provided for this, including how do they plan to enforce this? Because how do they distinguish between people having a one-night stand and getting pregnant and come back, as versus people having ART abroad and get pregnant? So that's my first 3 questions. Thank you very much.
Thank you very much for your question. The first question, Japanese, many ordinary people in Japan support the same-sex couple. But the politicians, they are old and most of them are men. You know, the Japan is what they say, so very conservative. And now Prime Minister is a woman, the conservative Prime Minister. Yeah, but she is not women's kind. She inherited men's way of thinking, so she is also conservative. So if the politician is making the draft or law, they add the ordinary people or women, many kinds of diversity at the working for drafting. Maybe the situation is changing, but I don't know the reason, but in Japan, the lawmakers always close meeting, so it's and they don't, that's not no public opinion. Yeah, so that's the reason, the first one.
What procedures to collect opinions from?
And second one.
这手机 ，why 这手机 so strong？ 那个什么咯？
你呀，related to the reproductive issues, ART, what they say, guide, the guidelines. So, and they respect in Japan, people respect the professional organization and the other way the politicians also respect the organization. But to tell the truth, this is really interesting. During the disagreement between the politicians and medical professionals, politicians claim that JSOG wants to maintain donor anonymity, but JSOG argued that it has no choice but to keep donor anonymity because to protect donors, the government has not established the donor legal status legislation. So here's the disagreement between the politicians and the JSOG. And so this time now JSOG working to issue some new guidelines, and they said they are really the politicians to donor is not
The question is about punishment.
Punishment. I want to ask everybody, but punishment
In the bill,
in the bill.
does it mention like how it implements the punishment?
Yeah, they, in the bill, the legal punishment was described, like, in this case, article, this case, we have to, improve, like that. But it's usually possible, and if that, mother had some treatment overseas, and she was a punishment, in the jail, who can take care of her child? I think it's not, I want to know your opinion.
And Bei Jie, you want to respond some of the questions because Bei Jie studies the ART in Japan.
Hi, thank you, Jia. I'm Bei Jie. I'm a postdoc researcher at Seneca, and my PhD thesis is about the ART experience in Japan. So that's why I know some of the situation in Japan. So for Professor Lei's second question, I think it's also because they so to begin with is that broadly speaking, concerning a lot of technology related topics in Japan, they do tend to use like soft regulations to regulate all these progresses, and they usually like stand at the position that we don't want to interfere too much because the technology changes quickly. So in terms of ARTs, they are also like from the very beginning, the government have already published several like announcements or like in their conference or in their meeting minutes that says we don't want to regulate it to also I think from my perspective it's also because it will serve doctors' interests, and that's also some doctors that also they that some of them told me this, to make them like the practice is easier, to create a vague space for them to play. But also there are quite a big cover like the heteronormativity. They would not like really step into the space that to like try to challenge this kind of framework. So and the other thing also, this is also my question to Professor Simba, I'm sorry, but is that we know that several Japanese doctors association or society, like they do support and they do like do this kind of same-sex, they do the therapies for same-sex couples, and I also know that they seem to have some kind of tension between these different societies, and I'm really like curious how their response to this kind of discussion when this law started to become a topic in the legislative process. And also the other question is that is there any factor in donor link Japan in your organization? Is there any very supportive and wanted to speak out something about their position on this issue? And also you showed in the presentation that there was a meeting those parents and people who use donor gametes stand out to support. I wonder if there's any other more story about how what the role of donor link Japan in this law deliberation process. Sorry. 2 questions so far.
Thank you very much. The first question, some doctors, of course, support LGBTQ couples or solo mother to become a conceive. And that the doctor, of course, I can say, of course, they are a member of JSOG. And in JSOG, the guideline isn't I can say, legally, what does it say?
They have to be married with documents.
Yeah, but the guidelines doesn't have a legal power. Yeah, so if they violate that guideline, they cannot. They don't lose their license. So some doctors
They speak out.
speak out just under the table. For example, some doctors in Japan provided surrogacy in Japan. The JSOG prohibited the surrogacy, but he provided surrogacy to patients. And one time the JSOG noticed it, and they withdraw his membership, but he came back, and the things happened. So some doctors support the doctor has their own opinion and way of speaking. So some doctors provide their activity for single women and same-sex couples, but they don't disclose actively. But there are people who want to know that information, of course, information to if they go to this doctor, they can access that technology. But the reason is that Taiwanese impacted same-sex couples come to Japan. And donating Japan. Japan.
Yeah, doctor.
Yeah, Dr. member, Dr. Fuji, now is the chairperson of the drafting the new guidelines. Yeah, and he's really active, and maybe in the past he was criticized for treatment by other people, and he has a strong opinion to support the conflict people. When I met him first time in 2003, so more than 25 years ago, donor should be anonymous. But he met many donor-conceived people, and he learned about the situation of the donor-conceived people, and he changed his mind, and he started to support those people. And he actively, as a doctor, he introduced, which now he said, should be published. So doctor, the young doctor, Dr. Fuji is not so young. But these days, young doctor changed their way. Most doctors said we should stop the but they need the law. We need a law that stipulates that donor is not the legal father. If that statement, if there is no statement of such a statement, they cannot protect the donor. No. So bad English.
Okay, so now finally, thank you very much. Thank you, Professor Senba, for the excellent talk. And it's very happy to have you here in Taiwan again. So I have one question. I'm just very curious about the reaction of the public to the donor conception bill in Japan. Has it raised like heated discussion, for example, on social media? And also, like, I'm very curious about the reaction of the younger generation.
Yeah, there are many opinions, of course, and older people. I sometimes give a lecture to older people at the city college, and they say they are not interested in this issue. Yeah, and they're so they say why that like for example the donor-conceived people like to know why they were raised by the parents, and if they say I want to know donor, it's when they hurt their parents, so they against to against the right of right to know, but young people have a different opinion. For example, I give a lecture at university and I introduced this issue, and many young people said that if I would be born by a donor conception, I would want to know the donor. So they understand the donor-conceived people feeling, but the generation, it's the dependent generation is different. But these days, almost 10 years ago, donor-conceived people didn't say anything, so they're quiet. So we couldn't learn what they think about. But in 2005, one of our members, such started to say, I want to know donor, and she talked her experience, and the real donor-conceived people see that person, and mass media featured her experience, and the situation changed. And these days, some people change their way of thinking, and donor meeting at the time for So if somebody started to argue that the situation
So I want to follow our instructions, but it's more about Taiwan. When I learned about the bill last year, I was really shocked. I think it would have a lot of implications for Taiwanese single women and lesbian couples to visit Japan. And Japan is also, Taiwan is also very important destiny for Japanese couples because as a couples who needs donated eggs and also now donated sperm. So I wonder whether my colleagues know that is there any response from the local community? For example, do the lesbian couple community feel that Japan might not be a desirable destination because they are going to have this law, and or whether the medical clinics might feel cautious about their customers who come from Japan. I wonder whether you, or we invited Singapore because we want our local community to feel, to know better about the regulation in Japan. Or in the past, I often feel that there were a lot of misinformation. For example, Japan legally allows that single women and lesbian couples to have the clinics. They may not get the right information. So that's my question. But we probably do not know, right? But I wonder whether you know, feel have any idea.
I haven't heard anything like that. I think the information hasn't spread in the communities, and I used to be in one group that all other members are going to Japan, but that group is dismissed now, so I'm not sure what's the response. And my feeling is they are actually quite cold to the legal changes. Yeah. I think it's also because, like William said, the time is ticking, and all the women who desire to have children will tend to do it as quick as possible, so they don't want to wait. Yeah, but I haven't heard anything about the legal changes in Japan.
Any questions from the audience? Really?
Thanks for Dr. Zemba's informative speech and so many information, and I think many know better about the debates and legal procedures in Japan so far. But I remember that you were excited to tell me that the JSOG has gradually shown the support of the states with Japan, donor link Japan since I think this year, right? And they also have an official statement that they support the children's right to know the origin. And this is the same support from the Japan Federation of Bar Association, the Lawyer Association, also very support because they are concerned about the Children's Rights Convention and also as part of the human rights development in Japan. So what positive influence might this have on the next stage of this diet field? This is a question for the Dr. Semba. And Sarah's comments made me think about what's the assumption in this Japan field. One example is the donor's desire of anonymity. And if the Japanese choose the identity disclosure, then the number of donors will drop. This is all the assumption in the bill, explicitly or implicitly. But do we have the evidence to show this assumption is right, or this assumption, how do we examine this assumption? And I think for this kind of question, compared to study from other countries, that the shift already helped to explain, for example, in Sweden and also in UK, it shows that maybe the number of donors will drop a little bit, but the number will come back, and maybe we just attract different type of donors. So this requires that follow up for this kind of information to make policy decision. And I think that this kind of comparative study can help us to not answer this assumption, but at least challenge this assumption, not only in Japan, but also in Taiwan's case. And I think the UK, the HFEA authority, and their transition from the anonymity to the identity release system, I think that requires so many political and also social force together. And I think that a good example maybe we can learn from this case, not like in Sweden, so that top down in the 1985, just because they think they are the pioneer of the human rights. So this is all the social and the political factors involved. And the last comment is about the this so-called reproductive tourism that Sarah mentioned about because the egg donation used to be prohibited in Germany, so they went to Spain or Ukraine, but they came back with like Johnny Saudi, they came back with the multiple pregnancy, and this increased the burden of the healthcare system domestically. And I think the Andrew Whitaker, she studied the Australia couple went to go to the South Africa to get sperm or egg donation, but apparently their expectation is so different because Australia couple think they can have the donor identity relief results that they can tell their children because that's the system in Australia. But in South Africa, the donors and also the clinics, they think they just think that the anonymity system can be continued. So this is kind of scenario happened in this reproduction tourism could create so many issues that as a researcher, so that could be very exciting. But for regulation, then how do this transnational reproductive care system to build up? That would be something we should think together.
谢谢玉玲。Yeah, we always pay close attention to what opinion the professional, who is what kind of opinion. And when we established the Donaring Japan, we went to the Donaring Japan. Our members are very interested in the donor concept right now, and we want to our aim to abolish donaring. And some agree with our opinion, so we went to such a professional and to support us or work with us. And Dr. Fuji, he is a medical doctor, OBGYN, but he agreed with us. And somewhere, of course, we have 2 lawyers, and they also agree with us. So such a professionals would include other professionals in the field. So that's a very important thing. So if we change the situation, what who is professional, who is the support with us, or who is the with our we recognize that, and we have to think this topic. It's important. And some group here hold up and so we yes. Is it answer? Okay,
Yeah, thank you, Yulin. Those are really helpful thoughts. I mean, from what I know, I'm not an expert, but just reading some of the literature on different countries in Europe, which have very different policies and also that change over time. I'm thinking about the newest French law, for instance, which mandates donor information disclosure. So there's significant changes over time as well. And I have heard that there are discussions within Europe about should there be regional guidelines for ART, since there is such dramatically different practices and norms. And the unevenness creates challenges such as the one you described, right? Burdens on public health systems because people go abroad and use resources and then have, for instance, multiple birth pregnancies and then not so good, bring on their home country medical systems. So I think that's an open question to be asked. You also have differences in cost structures and payment systems and who is eligible for state supported care and who is not. And so there's the kind of regulatory world that exists, but underneath that regulatory world are a whole set of assumptions about who is a desirable reproductive citizen and who is not, or whether we want to limit reproduction to citizens only, or open it up for, and this is sometimes where the medical profession comes in, for a broader set of care seekers who are also a source of financial resources too. I also want to introduce another concept that hasn't come up yet, which is quite circulating quite prevalently in the US literature, and that is the concept of donor siblings. And the use of, even when there isn't donor disclosure, the use of genetic testing, DNA testing, enables people who are conceived from the same donor to find each other. And then it is increasingly common among young people in their teens and 20s in the US, and they form online communities around donor siblingship. And what that means to them might vary, but it opens up, for them at least, how they understand family as well. And, I think going back to Professor Shamba's comments, right, this whole emphasis on a biogenetic basis for a parent-child tie as the most authentic thing, and the potential that parents will feel
threatened if their child wants to know who the donor is. There's also a lot we can learn from the literature on adoption that has delved deeply into this topic, especially around debates shifting between closed and open adoptions. But the idea that there should only be a circumscribed sphere for recognized familial ties, I think is something that adoption asks us to question, but reproductive technologies also ask us. So just putting that out there.
Thank you. And I have a follow-up of Elaine's questions about the transnational reproduction and donor anonymity. And I was very surprised to see that inheritance claims was listed as one of the reasons that donor anonymity is ideal, because that issue was so obvious in debates in Taiwan. They have this imagination that once there are connection, identifying information was revealed, the donor adults might find donors and ask for these, especially about sperm donors, not about egg donors. It seems sperm donors are richer than egg donors, and which has some basis because in the early periods, donors are doctors, right? Supposedly they are upper middle classes. So such imagination often revealed in soap opera or in the news reports, so that donor anonymity was justified. But as far as I know, in Japan, that's not the case. So my first question is why the inheritance claims emerge as a possibility? And Sarah mentioned that there are other cases in different countries, the openness and or some new policy. It has been introduced to Taiwan, but the first reaction from doctors is that these are Western countries, so we are different from them. Like sometimes they tend to demonize or some romanticize. They have the strong power to support this kind of diverse types of family, but not in Taiwan. But now there are some demands from Japan, for example. Garayama sensei come to Taiwan and they would like they have the donor constitution via the donated sperm from Taiwan. So, but they prefer to have some connection with the donors, but our legal framework does not allow that. So they would like to have the open donor system in Taiwan. So I think this kind of transnational reproduction has very diverse impacts. So I'd like you to respond. First about the poverty in inheritance. Right, what happens?
Yeah, the politician imagined that. We met many people, and they were from not poor countries. Yeah, they caring to educated, they have a good job, and so they provided a good education to their children. And so our member in the community in Japan, the people, so individuals, so we don't regard that was right. So who say that? Maybe politicians imagine that. It's not true. I think. Yeah.
So it's like male reach politicians, I also think that it has some implications about the extramarital affairs, like you have the children based on the extramarital affairs. They show up and they might claim for your property. But I also saw that that's not the case in Japan. It's the case in Taiwan. Like many entrepreneurs has some, how do you say that in a good way? Children, not
Conceived outside.
conceive outside marriage, right? And they want to have a DNA test in order to claim their property rights. But my Japanese colleagues told me that entrepreneurs in Japan also have a lot of extramarital affairs, but they do not claim their property. But maybe they are wrong. Anyway, where does this come from?
Don't conceive people and people who are born from out of marriage. It's totally, I think it's totally different. So in the case in the out of marriage, the people who are from out of marriage, some people have a financial problem. Such a case, they have a possibility, but I've never had possibility, but in the but in the protection case, most in Japan, the recipient is a heterosexual married couple, and their life is stable, so they can provide enough financial resources to the children. So I think the situations are different. So what do you think?
Well, I mean, I agree that empirically those economic situations of the different types of scenarios could be different, but I think they do share something, and what they share is probably reflected in the politicians' anxieties, which is how does one establish legal paternity in these cases, where there aren't other legal frameworks that are defining paternity. So it's not paternity defined within a marital relationship, or children conceived in non-marital relationships, or it is a third party being brought into an existing heterosexual marriage through gamete donation. So I think it's about paternity anxiety.
Okay, we're going to take a few questions. Is there any other questions? One may, then you. I would think that there's an analogy between open adoption and open donation. As far as I know, in Taiwan, the NGO that is facilitating adoption, they try very hard to persuade parents to tell their children that they are adopted. But so far, according to a newspaper from reporting on this NGO, they say that only 1/3 of parents are willing to tell their child that they were adopted, despite all the efforts in helping the parents how to disclose this fact and things like that. Because I think there's still some stigma for children that are adopted, and of course, I think parents are still very worried about their privacy or their authority over the child. They would feel threatened if they let their child know that there's someone else that is the real biological parents. So I'm curious that given in Japan, you started this Donor Link Japan and the advocacy for people that are wanting to know, I wonder how it is in adoption. Like, is there a stigma for people that are adopted, and whether there's a similar voice among people who are adopted that wanted to know, and are Japanese parents willing to share this information? So can you give us more information about Japan? Thank you.
Yeah. There is a long history. Yeah, there is a long history of adoption in Japan, and these days, not these days, around 2000, beginning of 2000, the adopted family, the parents should ask, I think the education is really the adopted parents were told, you should be told the children when they were young. Yeah, so they accepted naturally. But if you told when they teenager or older, they got shocked. So the agency provides education to the adopted parents and maybe donor conception thing. So these days in Japan there are some donor the parents group for donor conceived children, and they actively say you should tell the truth to your children, early age, and if they some parents disclose the children when they were 3 or 2 or more younger, and the children say something. One time I met one child, she is 11 years old, and she said, my mom was so asking to get the information. I don't care. This is my country. We don't have any genetic relationship, but this is my country. So they accept naturally. And I think that is important. So of course, the donor people need the donor information maybe in the future for in some case. But the most important thing is the parents don't should explore the truth. And if they don't say anything, then the children notice they were born from the conception. In such a case, the children would think, I was born by a birth in Nigeria.
So they did learn from adoption.
Yeah. And so, yeah, we sometimes collaborate with the adoption, other social worker or psychologist, other adoption. Yeah, and we have a social worker and a counselor, organization, and here for adoption.
Good to know. Hey.
Okay, thank you for the very informative talk. And my question is about the prohibition on the overseas reproduction. And I'm just wondering what's the assumption behind that prohibition, because like we know it's paternal anxiety behind the prohibition on the donor identity disclosure, or it has heteronormativity behind only heterosexual hierarchy. And I'm just wondering why the lawmakers in Japan refuses this overseas reproduction. It is like, is there a that's my imagination, like, is there an anxiety on the mixed race children, something like that? Because it, like, in contrast to the cases in Taiwan, like, we don't have that kind of anxiety. In contrast, we welcome mixed race children, especially when the donor is one person. So I guess I'm just curious why the Chinese lawmakers kind of rule and regulation.
Yeah, each country has a different regulation or legislation. And for example, in 2012, I don't remember the exact year, but some Japanese they were married. He and her wife went to India. And during the procedure, they got divorced. Yeah, and first time they went to there to use the explanation, but now they got the divorce. So here is the romantic here, but the wife doesn't want to bring it, didn't want to bring it. So he used the romantic, and the baby was born, but the India, in India, in Japan, India, can single guy, hungry man cannot adopt. So that baby doesn't have a nationality, so he couldn't take the baby to Japan. So his mother adopted. So such a case happened. So the law is a different in each country. For some reason, in Japan, you have the very simple right, in Japanese simple under the law. So that is the one reason. And the other one is if the couple or the person use the meat staff or institution overseas, most cases is a commercial. That's the one of the reasons. In Japan, the law is a commercial. Even now, no law, no, it's okay now. But so this is some people that couple or Christian couple or single woman goes to overseas before that law.
That's a good cover of the case. Our politicians usually say it's not legal here, sorry, but you can go abroad. That's our very common response. Right? So that's why we need to do some analysis. They're very much. So is there any other last questions? Any questions online? Are there any people online?
One question.
That should be your last question.
What don't recipients in Taiwan speak out? Because in Japan, some recipients said we needed some donor information to raise their children. And so one of the big power is the recipient parents. But probably in Taiwan, the recipient parents think same things. They need some information from the donor. Why they don't speak out?
I have two, I know two reasons. First of all, we do have a registry for people that are, use gametes to get conceived. And it does, the law does permit people to check when they are going to get married if the other side is related with them. And I once asked the government who are in charge of this registry, and did anyone check the registry? And they say no. Since the law, the registry was there since 1995, and since there was a law in 2007, but that was 2 or 3 years ago. I asked them, they say no. And we suspect the reason is that the parents never disclose that children are conceived by donation. So that's my first response. And my second response is that I learned from Australia. They started a very radical change on disclosing the donors' information because genetic technology, genetic testing directly appealing to consumers is quite popular in Australia. Like 23andMe, people accidentally discovered that they have donor siblings. But that's not common in Taiwan because compared to Australia, we are more homogeneous. For instance, we sweep our tombs, our ancestors' tombs, in April, and so pretty much everyone would know where they come from. At least theoretically, they know, even though they're probably conceived by donation. But that ceremony exists in every family. You're supposed to know even many generations who your ancestors are, and therefore we don't see the need. Partly because they don't know they're conceived by donation, and partly we don't have genetic technology that's common in Taiwan. Mostly the genetic technology is used for medical reasons, not for searching for identity or genealogy reasons. So that would be my true response to your question.
My siblings,
in Japan, how many children were born from one donor? We don't know. So that's a different from Yeah, and DNA testing, the DNA testing is not popular in Japan either. But we have the disaster, we have many disaster or so, and DNA testing is really important. And in some cases, we never have such a record. For example, we are meeting my parents for benefits and using the DNA test. And your parents is coming and see the different person for such a case, your husband is a huge. So DNA test shows the very close relationship, but I've never seen this one. I've never seen this one, don't know this one, such a thing happening. And we say the DNA testing is coming to our life, our society, so we should think about it. This means so in the year of right? So people think about it. And one more thing, in Taiwan, most of the recipients think like if they want to help the first to the children that don't realize the role of picture. But in Japan, in our organization, most donor conceived people feel curious. Something strange. Because one case in Japan, New Year's Day or some event, family gathering, we have family gathering in the US for Thanksgiving or Christmas time. And at the time, baby was born, and people talk about, oh, this baby looks like grandpa, or she looks like her father, or like that. But in my family, we never had such a problem. And the family gathering, such a discussion started. My parents were like that. Nervous and why don't we be here in the show? Something strange. So I think the children, especially children, not so naive.
Thank you so much for Sara Sensei's wonderful presentation and Sara's comments and all the comments and questions from the participants. Indeed, in Taiwan, we don't have the stories, not single story of donor conceived adults from the heterosexual families. But if you want to know more about the Japanese ones, you can attend the talk tomorrow afternoon at the feminist bookstore from 2:30. So Sara Sensei will talk about this book in Japanese, and Ili will be the interpreter, and Yulin will chair the talk. And if you feel impressed by Sarah's comments, you can come to her talk next Thursday noon at Sociology Department seminar room. Don't come here. And I will share the talk. So we have more to discuss in the future, next week. All right, let's give a big hand to both Sara and Sarah. The event is organized by Chinese Feminist Scholars Association. Our president, right, sometimes. Oh, do we have a photo? Yeah. All right.